Divorce disputes can be emotionally challenging. Choosing the right resolution method can make a significant difference in how that process goes for you. Today, I'm going to provide an overview of 5 different options to help see what might be the best fit for your particular situation. The first option that probably is something you've heard about before or heard people talk about is called mediation. Mediation is a smart way for 2 people to try to work together with a neutral third party and resolve their differences in a way where they have mutual agreement and some input into the outcome. This method is typically used if you can have open communication with the other party. If you want to keep control over your decisions, this is a good path to take. However, sometimes it's not going to go where both people are simply going to agree. In situations, unfortunately, if there's been any kind of history of difficulty communicating or a history of abuse that's leading up to the end of the marriage, then you might want to choose a different method. Another option, where if the parties are still agreeable, is called a collaborative divorce. That's where you have a team of professionals. If you potentially have some more difficult or complex issues to resolve, maybe just a mediator isn't going to be sufficient to get to the end of the decisions on how you're dividing assets and making major financial decisions that affect you for a long time. This helps you kind of review all different aspects, but you come to your final agreement again through an agreement that gets submitted to the court. If that process doesn't work, then maybe you want to move into something where you have a little bit more control over what happens in the outcome. And that might happen if you have an arbitration where you choose the arbitration as being mandatory. And if the arbitration is going to result in an absolute final decision that you can't change after both parties get to it, then a binding arbitration might be a good way to come to agreements without going to court and have it be a little bit less expensive. If all those methods aren't cutting it, then you will have to go before the court, and that is known as litigation. And only about 5%, I would say, of contested matters go this method, but it will if you can't come to agreements on primary major issues regarding finances, assets, how you're going to share the time with your children. And this pathway will likely be the most expensive because you are now engaging attorneys on both sides, and it's taking a lot of time and their time. Finally, you don't have to have a lawyer. Parties can go down to the courthouse and file and do it themselves unrepresented. And this is called the Latin word pro se, and it means self-represented. It lets you handle the dissolution action yourself, and it helps save you any costly attorney's fees. Not recommended unless you have a pretty straightforward case. If you have some complexities, then you likely would need to have guidance from a professional. So all these different pathways have different pros and cons, and really the right choice depends on your particular set of circumstances. Having somebody who's knowledgeable and experienced help guide you in making these important decisions is really going to be critical in how this outcome goes for you. So if you want to help make some good decisions for your future, thank you so much for watching, and please reach out.